Good day everyone. In today's video, we're going to examine a local and national government policy that protect the well-being of the person in the face of new technologies. And I'm going to discuss or tackle about the RA 10175 or the Cybercrime Prevention Act of 2012. So, if you're going to ask me what is cybercrime, well, have you ever received an email saying that you have won a worth prize of 5 million pesos from the PCSO? And according to the email, all you need to do is provide the sender with your bank account number and he will put the money in your account with saying that making you an instant millionaire. Sometimes this way actually works. As a result, unfortunate individuals who provide their bank account numbers to the sender and later they will discover that their accounts had been cleaned out. Actually, cybercrime first started with hackers. The hackers trying to break into computer networks. Some did it just for the thrill of accessing high-level security networks, but others sought to gain sensitive, classified materials, or they were just having fun. Eventually, criminals started to infect computer systems with computer viruses, which led to breakdowns on personal and business computers. Computer viruses are forms of code or malware programs that can copy themselves and damage or destroy data and systems. When computer viruses are used on a large scale, like with bank, government, or hospital networks, these actions may be categorized as a cyber terrorism. Example of cybercrime, uh, like writing or spreading computer viruses or malware, like digitally distributing child pornography, like the fraud did by manip- manipulation computer network, and also unauthorized access to or modification of data or application, and many more. We also have cybercrime attack types. The first one is hacking. It is an act of gaining unauthorized access to a computer system or network. The second is denial of service attack. In this cyber attack, the cyber criminal uses the bandwidth of the victim's network or fills their email box with spam email. Spam email. Here, the intention is to disrupt their regular services. Software piracy. Thief of software by illegally copying genuine programs or counterfeiting. It also includes the distribution of products intended to pass for the original. Phishing is a technique of extracting confidential information from the bank, financial institutional account holders by illegal ways. Spoofing. It is an act of getting one computer system or a network to pretend to have the identity of another computer. It is mostly used to get access to exclusive privileges enjoyed by that network or computer. So, cybercrime consists of illegal activity conducted on a computer. Traditional crimes may be committed while using a computer, but cybercrime consists of more specific types of crimes, such as phishing, hacking, and viruses. For the history, The Cybercrime Prevention Act of 2012 is one of the first law in the Philippines which specifically criminalizes computer crime, which prior to the passage of the law had no strong legal precedent in Philippine jurisprudence. While laws such as the Electronic Commerce Act of 2000 or the Republic Act number 8792 regulated certain computer-related activities. These laws did not provide a large basis for criminalizing crimes committed on a computer in general. For example, Onel D. Guzman, the computer programmer charged with purportedly writing the "I love you" computer worm, was ultimately not prosecuted by Philippine authorities due to lack of legal basis to, to charge him under existing Philippine laws at the time of his arrest. The Cybercrime Prevention Act was ultimately the product of House Bill number 5808, authored by Representative Susan Yap Sulit of the 2nd District of Tarlac and 36 other co-authors, and Senate Bill number 2796, proposed by Senator Edgardo Angara. Both bills were passed by their respective chambers within one day of each other on June 5 and 4, 2012, respectively. Shortly after the impeachment of Renato Corona, and the final version of the act was signed into law by President Benigno Aquino III on September 12. In addition, Senator Edgardo Angara, the main proponent of the act, defended the law by saying that it is a legal framework to protect freedom such as the freedom of expression. He asked the act's critics to wait for the bill's implementing rules and regulations to see if the issues were addressed. He also added that the new law is unlike the controversial Stop Online Piracy Act and Protect IP Act. However, Senator T.G. Guingona criticized the bill, calling it a prior restraint to the freedom of speech and freedom of expression. When is the law created? Cybercrime Prevention Act of 2012, officially recorded as Republic Act number 10175. It is a law in the Philippines that was approved on September 12, 2012. It aims to address legal issues concerning online interactions and the internet in the Philippines. Among the cybercrime offenses included in the bill are cybersquatting, cybersex, child pornography, identity theft, illegal access to data, and libel. On October 9, 2012, the Supreme Court of the Philippines issued a temporary restraining order stopping implementation of the act for 120 days and extended it on February 5, 2013 until further orders from the court. But on February 18, 2014, the Supreme Court upheld most of the sections of the law, including the controversial cyber libel component. Who are the beneficiaries of this act? Actually, we are the beneficiaries of this act. So, it was being implemented so that to minimize or lessen the loss of information, money, data, families, or something like that. That is why it was being implemented, because from year 2003 up to year 2012, A total of 2,778 cybercrime-related offenses were recorded by the PNP. While the country awaits the implementation of comprehensive cybercrime law, as cybercriminals continue to use technology both in conducting criminal activity and preventing its detection. This trend is in criminal um, activity uh, necessitates the need for a dedicated unit within the PNP to go after these offenders and improve its cybersecurity posture. And in addition, from year 2010 to year 2012, the PNP has recorded a total of 1,184 incidents, with the highest being the attacks targeting government websites, where a total of 940 website defacements have been recorded. So uh, from that is why um, Cybercrime Prevention Act of 2012 was being implemented, and we are the beneficiaries of this act. Chapter 1, which is Preliminary Provisions. Under Section 2, the Declaration of Policy. The state recognized the vital role of information and communications industries such as content production, telecommunications, um, broadcasting, electronic commerce, and data processing in the nation's overall social and economic development. The state also recognized the importance of providing an environment conducive to the development, acceleration, and rational application and exploitation of information and communications technology, or ICT, to attain free, easy, and intelligible access to exchange and or delivery of information, and the need to protect and safeguard the integrity of computer and communications systems, networks, and databases, and the confidential confidentiality, integrity, and availability of information and data stored therein, from all forms of misuse, abuse, and illegal access by making a punishable under the law such conduct or conducts. In this light, the state shall adopt sufficient powers to effectively prevent and combat such offenses by facilitating their detection, investigation, and prosecution of both the domestic and international levels, and by providing arrangements for fast and reliable international cooperation. For Chapter 2, which is Punishable Act, under Section 4, the cybercrime offenses, uh, these are offenses against the confidentiality, integrity, and availability of computer data and systems. The first one is illegal access. Access to a computer or any application without permission. The second one is illegal interception. Interception of any non-public communication of computer data to, from, or within a computer system by an unauthorized person. Data interference, unauthorized tampering with destroying, deleting, or deteriorating computer data, electronic documents, or electronic data messages, as well as the introduction or transmission of viruses. Um, this provision can also cover authorized activity if the person's behavior went beyond the agreed upon scope and resulted in the damages listed in this provision. System interference, and authorized interference with the operation of the computer or computer network, including introduction or transmission of viruses by inputting, transmitting, damaging, deleting, deteriorating, altering, or suppressing computer data or programs, electronic data messages, or by deleting, deteriorating, altering, or suppressing them. This provision can also cover authorized activity if the person's behavior went beyond the agreed upon scope and resulted in the damages listed in this provision. Misuse of devices is the next one. And authorized use, possession, production, sale, procurement, importation, distribution, or otherwise making available of gadgets, computer programs, or other materials developed or adapted for committing any of the acts listed in Republic Act 10175. Unauthorized use of the computer password, access code, or similar data that allows the entire or a portion of the computer system to be accessed with the intent of using it to perpetrate any of the offenses listed in Republic Act 10175. The last one is cyber squatting, acquisition of a domain name in bad faith on the internet to profit, deceive, and harm reputation and prevent others from registering it. This includes trademarks that were already registered at the time of registration, names of people other than the registrant, and trademarks that were purchased with intellectual property interest in them. Those who get domain names of prominent brands and individuals who in turn are used to damage their reputation can be sued under this provision. Note that freedom of expression and infringement on trademarks or names of persons are usually treated separately. A party can exercise freedom of expression without necessarily violating the trademarks of a brand or the names of expression. I mean person, the names of persons. For computer related offenses, we had also computer related forgery, unauthorized input, alteration, or deletion or computer data that results in inauthentic data with the intent that it be considered or act on for legal purposes as if it were authentic, regardless of whether the data is directly readable and intelligible or the act of knowingly using computer data that is the product of computer-related forgery as defined here to perpetuate. The next one is computer-related fraud, unauthorized access to, alteration of, or deletion of computer data or programs, or interference with the operation of a computer system with the purpose to cause damage. The next one is computer-related identity theft and authorized acquisition, use, abuse, transfer, possession, change, or deletion of any individual's identifying information, whether natural or legal. We had also content-related offenses for C. Cybersex for favor or consideration, willful engagement, maintenance, control, or operation directly or indirectly of any lascivious presentation of sexual organs or sexual activity via our computer system. The next one is child pornography, unlawful or banned activities conducted through a computer system as defined and punished by Republic Act Number 9775 or the Anti-Child Pornography Act of 2009. The libel, act of libel that are illegal or forbidden under Article 355 of the Revised Penal Code as amended and are committed using a computer system or any other similar means that may be created in the future. Penal Code revision according to Article 355 libel is defined as defamation of character by writings or other means. Libel committed by writing, printing, lithography, engraving, radio, phonograph, painting, theatrical exhibition, cin- cinematographic, cinematographic, or any other similar means is punishable by prison, correctional for the minimum and medium periods, or a fine ranging from 200 to 6,000 pesos or both in addition to any civil action that the offended party may bring. For section 5 under chapter 2, other offenses, aiding or abetting in the commission of cybercrime. Anyone who knowingly assists or abets the conduct of any of the offenses listed in this act will be held accountable. The second one is attempt in the commission of cybercrime. Any person which is any person who willfully attempts to commit any of the offenses enumerated in this act shall be held liable. All crimes defined and penalized by the revised penal code, I mean, as amended and special laws, if committed by, through, and with the use of information and communications technologies, shall be covered by the relevant provisions of this act. And for the advantage of Cybercrime Prevention Act of 2012, the first one, cyber sex, cyberbullying, child pornography are now offenses, and such offenders can be punished. The children's rights are protected by this act. The second one is all kinds of businesses using the internet as a medium are protected by this act. The third one is provisions of this act now define the offense of cyber squatting, and this deters people from the act of cyber squatting. Provisions that penalizes online identity theft. This provision protects the individual's privacy and its protection. And let's go for the disadvantages of the uh, RA 10175, or the so-called Cybercrime Prevention Act of 2012. The first one is ambiguity in the terms given in the act, such as the term online libel is not defined anywhere, which can lead to different interpretations. Ambiguity can be seen in the provision of real-time data collection. The second one is the ambiguity in the act may lead to the freedom of speech. The ambiguities, like the absence of a proper definition of online libel, may lead to confusion. Sometimes the expression of some truth may be misinterpreted as libel. People may be restrained from expressing themselves. The last one is the implementation and execution of this act yearly costs a huge cost to the government. And now we're going to use a technique, the so-called SWOT analysis. Uh, the strength of this law is preemption, prevention, and prosecution of cybercrimes. In order to stop, to prevent the cybercrimes, such as uh, offenses against the confidentiality, integrity, and availability of computer data and systems, those computer related offenses, and those also content related offenses. And for the weakness of this act is for powers, because uh, the state shall adopt sufficient powers to effectively prevent and combat such offenses by facilitating their detection, investigation, and prosecution at both the domestic and international levels, and by providing arrangements for fast and reliable international cooperation. For the threats of this law or act, the first one is environment, and it could be also politics. And for the opportunities of this act, maybe the children's right or business uh, succeed or successful, and information safety. That is why it was being implemented in the Philippines, and also it could be used by the other country or in a countryside. That's it. Therefore, I conclude that in order to avoid cybercrime, loss of personal data, information, money, and being fraud by someone, um, we must be always aware. We don't have to trust people that we just only met yesterday or something like that, and we don't have or we don't need to worry too much because uh, the state the state or the government had to ensure the safety of ourselves, especially information, money in families. The Cybercrime Prevention Act of 2012, or the RA 10175, uh, is vital to upholding the protection of every individual, every citizens in the Philippines, every business and government that can fall a victim to these crimes. And I guess and that would be all. Thank you so much for listening.